Hello, can anyone hear me?
Yes, we can hear you, Mr. Schumacher.
Thank you.
All right, it looks like we've got everyone present. We can get started. Today is Thursday, April the 18th, 2024. The Board on Professional Responsibility is convened in the matter of Matthew B. Tully and Greg T. Rickney. Board docket number 22-BD-025. Will the parties please identify themselves for the record, starting with disciplinary counsel?
Hamilton Fox for the Office of Disciplinary Counsel.
Thank you. Respondent?
Dan Schumacher for respondents.
Thank you, counsel. Let the record show that Michael Tiger, who is one of our attorney members, is recused and will not be participating in this case. We are here on exceptions to the hearing committee report from respondents, who will proceed first. You'll have 20 minutes, Mr. Schumacher. Do you want to reserve some of your time for rebuttal?
Yes, please. I'd like to reserve 5 minutes for rebuttal.
Okay, you may proceed.
May it please the board? Our briefs, as you've seen, raise a lot of exceptions, many of which I don't expect to be able to cover within the time allotted today. So I'd like to focus on 3 core issues that I'll summarize first before getting into the weeds. First, the conduct at issue here involves the firm's use of employment templates during the years 2010 to 2018. We've asserted that DC's rules do not apply in a prosecution against these 2 New York-based respondents. Second, if you are to conclude that DC's rules do apply to at least some of the conduct, then with respect to the Rule 5.6 violations, we would suggest to you that the Gentner decision in 2021 should preclude either a finding of violation or, at minimum, the imposition of sanction under 5.6. And whether you reach that through our due process arguments or through the court's first impression precedents, doesn't matter much. It's the same outcome. On the 8.4D claims,
Mr. Schumacher, I don't want to interrupt your statement of your 3 core issues, but can you explain how Bentner would apply to help you when there is, what is it? It was 2015 or 2016 that there was legal ethics opinion number 368, specifically inspired by respondents, that very clearly addressed all the issue, really the main issue here today under 5.6.
Sure. So the respondent's firm modified its templates promptly after the issuance of LEO 368. The suggestion has been made by both the hearing committee and by disciplinary counsel that 368 was nothing new. It was just amalgamation of or reiteration of prior LEOs. But if you read the Gentner case, our read on that is the court is announcing for the first time something that the court believed was not clear. The rule on its face does not describe what the Gentner court refers to as partial or indirect impacts on competition. And the very first page of the decision says, we're publishing this decision so that the bar is alerted and aware on notice of what we think 5.6A actually prevents. You go through the Gentner decision, and it spends very little time talking about DC bar LEOs. It's doing an analysis of some other cases from around the country.
Mr. Schumacher, excuse my interruption, though, is not, you're referring to 368, as did Ms. Sargent, but does not guidance from the DC disciplinary system go back as far as 87 with ethics opinion 181, talking about liquidated damages clauses and the impact that they have on a lawyer who may be deciding to leave a firm, and that is something that can run afoul of 5.6. designed to allow lawyers to move freely between law firms.
So that is what we think 181 partially informs the bar.
Okay.
If you read 181, it talks specifically about two other LEOs that one of them, LEO 97, allows and says it's ethical to have an agreement, an employment agreement that approves the prohibition on direct solicitation of clients, as long as the agreement allows for a standard, what we used to call a professional announcement back in the day. The opinion 97 doesn't mention what the penalty was, but if you look at the other LEO that 181 references, that's LEO 77. And LEO 77 is really extraordinary in terms of its reach. In 77, you've got a 3-year non-solicitation clause that's coupled with a financial penalty equal to $4,000 per year of employment, plus a clawback of whatever bonuses that same employee received during each year of employment. So let's imagine you worked here for 10 years, you left, you start actively soliciting the clients.
Mr. Schumacher, appreciate that, but isn't the essence of Rule 5.6 saying to the bar that lawyers should not be hindered in their decisions to move between firms, and that's derived from the fact that a lawyer and a client relationship is sacrosanct. And so a lawyer should be able to move and should be able to take their clients with them when they do so. How is the agreements your clients have drafted, explain to us your best argument of why your agreements do not run afoul of that precept?
Okay, so all of the prior LEOs before 368 are based on a balance of what's the restriction and what's the penalty. The penalty in 181, as an example, was a perpetual restriction on multiple things, including operating in tandem with somebody else who used to work at the same firm. And the penalty there was $150,000 in 1987 money. So the difference there prior to 368 is what I would say is quite a bit of confusion in the bar. When, to the extent you've got lawyers actually reading these LEOs, you've got 77 that is approving of what could be a substantial penalty for competition under Gentner, let's say, and yet the LEO was there. 368 comes out and purports to, clean up the mess in the prior LEOs. And looks like it's attempting to bring clarity. It doesn't say in 368 that, everybody should have known this all along. And that's the same theme, we believe, in the Gentner decision. You look at Gentner, and it's dealing with a 1997 partnership agreement that contains a 50% forfeiture clause if you're going to leave here to go to another firm. 50% of your capital account gets wiped out because you're going to compete against the firm.
Yeah, can I stop you for a second? Because I guess I have a fundamental issue with this entire line of argument, which is we're starting, as I understand the argument, and you can feel free to correct me if I'm wrong. As I understand it, you're saying that until there's decisions out there that are interpreting Rule 5.6, lawyers are sort of off the hook until they get some sort of clarity as to what the rule means. And that, I think, assumes that the rule itself on its face is ambiguous. I mean, if you look at Rule 5.6a, and I'm reading directly from a rule, partnership, et cetera, or other similar type of agreement that restricts the rights of a lawyer to practice after termination of the relationship, except in an agreement concerning benefits upon retirement. So the restrictions are pretty clear to me. But then if I follow your argument, you have the DC Bar opinion coming out 368, but that wasn't good enough, I guess, to give your clients enough notice as to how they should structure their agreements. So then you have to wait until Gettner. But then I look at Gettner, and Gettner is actually citing to the DC Bar's ethics opinion pertaining to your client in terms of how it's reviewing the same rule that you claim to be ambiguous on its face, requiring interpretation. So I'm unclear as to why, if the opinion that you're looking at, or that you're saying that we should rely on, is in itself citing to the ethics opinion concerning your own client, why do we need Gettner for that? Why couldn't we just look at what the DC Bar did for you guys back, I forget what the date of the opinion is.
2015 for 368. Let me give you two answers to your question. So it's not unusual for the Court of Appeals, years after an LEO comes out, to issue an opinion that says, oh, we like that LEO. And that appears to me to be essentially what the Gettner Court has done. Now, if this was also patently obvious to the bar, I'm sorry, did I just step on somebody? Okay. So if the Gettner outcome was also obvious to the bar, then we might have expected, for example, that the Superior Court judge who handled the Gettner case, or even the Court of Appeals, might have, summarily thrown the thing out with language that indicates this is, crazy litigation. You should have known that what you've done here is outrageous under 368, and civil sanctions under a Rule 11 type standard could have been imposed. We don't have that here, though. And the court has literally gone out of its way on the first page of its opinion to say, look, we're doing this to make sure the bar knows what we're trying to say.
What did your client do differently after LEO's 368 was issued?
Yeah, so that would be the second half of my answer to your question a moment ago.
And then the follow-up question or question is, what did your client do? What didn't your client do with respect to, actually, first, if you could answer that question first, what did they do differently after it was issued?
So the LEO came out and the firm very promptly removed every clause in the agreement that looks like an indirect or a partial restriction on competition. So that would include, they got rid of the so-called anti-cohabitation clause. Got rid of.
Just focus on the liquidated damages part. Yeah. What did they do with respect to that?
So, well, all the liquidated damages for things that looked like competitive restrictions were taken out. They continued until sometime in 2018 to have the liquidated damage clause for early departure from the firm. However, the early departure clause was not tied to competition. Now,
did it pertain to their professional autonomy, though?
Well, we don't think it does under both Gettner, Lord Day, which our counsel likes to cite as a lead case, or under Ashcraft and Jarrell. So like under Ashcraft and Jarrell, there was a $400,000 forfeiture clause merely for leaving the firm.
Mr. Shumack, just let me follow up on Mr. Horace's question. Rather than us getting bogged down in financial numbers about what is or is not a substantial financial hit to a lawyer, in 368, it says, 5.6 exists, quote, because limiting a client's freedom in choosing a lawyer and lawyer's professional autonomy is not something that we would like to do as a profession, and therefore partnership employment agreements or other agreements that expressly or impliedly restrict a lawyer's practice is prohibited. It then goes on to say that prohibition extends to absolute bars on competition and, in some circumstances, restrictions that pose a substantial financial penalty on a lawyer who may compete. So if you can explain to us, without using the numbers of past cases, how the liquidated damages clause that your clients included in their agreements was not a substantial financial penalty for them to leave and go to another law firm.
Well, again, we think 368 is limited in its opinion to competitive restrictions, explicitly competitive restrictions. If you have a liquidated damage clause under the Ashcraft and Jarrell case that says, look, you can, when you leave here, you can go to the government, you can go teach at a law school, you can move around the corner and compete with us. We don't care what you're doing. When you leave here, you have some clawback that the firm is going to have. And under Ashcraft and Jarrell, it doesn't seem to matter how big that penalty is.
But Mr. Schumack, you're not doing a clawback. You're doing a liquidated damages clause, which is substantially different than a clawback, correct? Those are two different ways to assert damages against a counterparty, are they not?
So 368 uses liquidated damages in the vernacular, and you can see that with the other opinions that they cite to. For example, when they cite to LEO 77, they talk about the penalty in that instance as liquidated damages. They talk about things that are mere percentage claims as liquidated damages. They seem to be using liquidated damages in 368 as if to cover anything that can be like mathematically computed without discretion.
So, but didn't your clients and respondents' agreements use the term liquidated damages? Am I wrong on that?
Yeah, well, we've got two periods in time. We've got the template that was used up until 2015 when 368 comes out, had financial damages attached to certain, indirect competition, like setting up shop with another lawyer from the firm. After LEO 368 came out, the firm continued to use the early departure clause for a liquidated damages amount. And that liquidated damages amount, we would suggest, is consistent with both the Ashcraft and Jarrell holding, as well as the court's decision in Gentner. Gentner itself is only talking about
Mr.
direct
Schumack, though,
competition. Yeah.
You're the liquidated damages clause that were in your client's templates affixed a dollar amount that a departing lawyer had to pay, regardless of any other situation, right? So if that lawyer, billed zero work, had zero client activity, they were going to have to pay some dollar amount. If that lawyer billed a tremendous amount and garnered the firm hundreds of thousands of dollars, they would have had to have paid a dollar amount. You use the term clawback. Explain to me how your damages clause was a clawback and not a liquidated damages clause.
It is a liquidated damages clause, just like what I would also call a clawback in 77, LEO 77, when the firm is entitled to take back the bonuses that had been paid out over the years. It's a damage calculation. They're taking back, an equivalent amount of what they had paid out. But yes, it's a liquidated damages clause. And with respect to the early departure clause, the early departure clause had exceptions for the liability for someone who was terminated without cause, or for somebody who resigned with cause. Otherwise,
well, the only clauses,
the
only, if my recollection serves, the only reason somebody could quit if there was illegal or unethical behavior. Other than that, they had to stay for the full term of their agreement, correct?
Well, everybody had a slightly different clause. They were all similar. There was a good cause exception in there. It's in the record. You can read it. It's certainly not the broadest thing, I agree with you. It wasn't, you can leave for any reason. But these were term of employment contracts that these people got hired onto because they wanted them, because the contracts were tied to higher pay than market. We had,
Okay,
everybody was
Can I
testifying,
ask one
yep, I
question?
came there because the pay was great.
About
Yeah,
your-
I'm sorry, Mr. Hoare, you go ahead. But I do want Mr. Schumacher to get back to what he
Yeah, no,
opened.
that's what I was going to ask, actually, about
Okay,
choice
great.
of law. I was going to bring this back. What is your best argument, sir, that the New York law should apply? And even if it applies, what aspect of New York law or what case can you cite to that points us in the right direction, that says your client did everything right, at least under the New York bar's ethics rules?
So the standard here is under DC's choice of laws. You've got the possibility that if we're talking about litigation matters, then we're supposed to be looking at the tribunals. If it's not a litigation matter, then we're supposed to be looking at where does the respondent principally practice. There's no question here that the respondents principally practiced in New York. That was never a dispute. The only question is, do we have to get into the predominant effect clause? I have cited for you in the brief one of your own board opinions in 2006 Mance case, where you've laid out tests for, when are we going to look at the predominant effect? What should we be looking at? And your test in that case is almost exclusively looking at impacts on clients. It's, where do the clients live? Where do the clients work? Where does the firm deposit the money that the client is sending? Things of that nature.
Just in the
all
interest
these
of
things
time,
point to
sir,
New York.
Mr. Schumacher, if we could just move on to the second part of the question, I think we understand your argument about that. With respect to how New York law helps you, I'm looking again at this Gettner case that's cited, I think, 48 times in your brief. And I'm looking at the fact that in their interpretation of Rule 5.6, they write the Rule 5.6 equivalent based on reasoning perhaps best articulated by the New York Court of Appeals in Cohen v. Lord, Day and Lord. And then they cite to that decision, which basically comports with legal ethics opinion 368. So I'm just wondering, where in New York law do you find anything that's different with how we should hold here today, or how the Court of Appeals should ultimately decide this issue, given the fact that New York law is cited by the DC Court of Appeals?
Right. So the Cohen versus Lord Day case is a forfeiture for competition case. The lawyer in that case had contracted to lose all of the receivables that the firm had not yet collected on the work that he completed prior to leaving the firm. The case doesn't say how much money that was, but the New York's top court viewed that as a forfeiture for competition. And what's key there is that forfeiture clause only applied because Cohen was intending to set up shop in competition to his old firm. So it's the same thing, right? You're asking me what's wrong, with this clause that continued after 368 for early departure. Well, the early departure clause that my respondents had was not a forfeiture for competition clause. There's no competition required. Didn't matter why you were leaving. If you breached your commitment to the length of term of employment, then you could be asked to pay some stated figure for liquidated damages. The other issues in New York, for example,
getting back to your clawback argument, right? A clawback is a contractual provision that requires an employee to return money already paid by employer, sometimes with a penalty, right? You agree with me that that's the definition, right?
That sounds fair. Yeah.
Yep. Google will agree with us as well, because I just read that from Google. Okay. So getting back to the New York case that you just cited, that we just talked about, where you said that they specifically talk about forfeiture, which is what a clawback agreement is. So why wouldn't that opinion from New York apply here?
Well, because it has to be about forfeiture for competition. So there's some other
Mr.
elements in New
Schumack,
York.
can you give us, you use the term competition neutral, and you say that your clause works because if a lawyer leaves inside of the time period they agreed to stay with your client's firm, they're still going to get the liquidated damages clause. Can you explain to us the case, the ethics opinion that you are relying on that says a competition neutral reason is, and then explain what it is so that we can understand where that definition is coming from?
So competition neutral as a phrase was repeatedly coming out of Mr. Rinke's mouth when he testified. So it's not a term of art, but if you were to read the Ashcraft and Jarrell case, what you will see there is Ashcraft and Jarrell approved a $400,000 liquidated damages clause for a guy who was leaving the firm without respect to what he was planning to do next, because the agreement in the firm applied if you were, again, you could go into the government, you could
Mr. Schumack,
retire.
Mr. Schumack, okay, on competition neutral. What about the Felon case out of the New York Court of Appeals that says if a departing lawyer is going to incur financial cost to leave a firm, they quote unquote would be compelled to inform clients who wish to follow that lawyer that they may not be able to continue to represent the client because it would be a inconvenience and financial cost to them to be able to continue to represent that client. And it would be difficult for the lawyer and for the client. And that is the Felon case out of New York, which seems very similar to what we have in 5.6 and the 5.6 ethics opinions.
Yeah, well, I would agree that the Thalen case uses those words, but if I'm remembering the fact pattern in Thalen, it is also a case about competition, right? There was specifically a competitive threat to it, as opposed to the same.
Okay, so assuming arguendo, it was a case about competition, then could not the same apply that if an attorney was working in your firm, in your client's firm, under these agreements, and there was the decision by that lawyer to leave to a competition neutral position, let's say with a legal aid society, would that not have the same impact then? That lawyer would not be able to make that decision because they would have to pay your client's firm some dollar amount on the way out, and therefore inhibiting that lawyer's ability, because of the financial hit they were going to take to go work for somebody that wasn't even in competition with your firm, and such that a lawyer would be prohibited or their decision to go work in a nonprofit environment would be impacted. Same theory applies even if it's competition neutral. Would you agree?
I do, but that seems to be what Ashcraft and Jarrell says is the dividing line between a 5.6 violation and not a 5.6 violation.
Okay. Okay, yes, go ahead.
No, I'm sorry, Margaret.
Thank you.
Ms. Cassidy, go ahead.
I think Mr. Schumack's last responses can be extrapolated into my next question as an answer. Thank you.
So two things, Mr. Schumack, you opened up kind of with maybe it was a rhetorical device for you to say that applying DC rules to these two New York-based attorneys, that was your first core issue. Apart from the choice of law issues, which you've gone through with Ms. Cassidy and Mr. Hoare in detail, you're not arguing here substantively that the DC bar, that we don't have jurisdiction over your clients because they're New York based. That's not one of your arguments, is it?
Okay, so jurisdiction is different than which rules are supposed to be measuring their conduct.
No. Well, then let me retract that word jurisdiction. You are not saying that this board doesn't have authority, or that the hearing committee doesn't have authority, or that Office of Disciplinary Counsel doesn't have authority over your clients because they're New York based. That's not what you're saying.
No, we've never argued that. They have
Okay.
DC bar licenses. They fall within the purview of the Rule 11A clause of who can be investigated and sanctioned.
Okay.
The question, though, is what rules are they entitled to be prosecuted under?
Okay, and I think we've been through that. I'm just going to give you a chance to say what your third core issue was, and then we can see if there's any questions on
Right.
that.
If I could add a little bit more meat to the New York questions.
No, I think if you're
Okay,
going to
I
make
mean,
more choice of law arguments, then
No, I
maybe-
mean, there's a lot of prejudice associated with not applying New York laws, right? So New York looks like it's similarly worded, except New York doesn't have DC's comment 2. So we don't have the substantial financial penalty language in New York's rule. New York appears to be willing to accept savings clauses in order to avoid an ethics issue.
Now, is that in a venue of litigation over professional responsibility, or is that in a venue of commercial litigation, like an arbitration over a contract?
Right. So we've got 2 LEOs from New York that we cited in the reply brief that deal with savings clauses. Usually, if it's an LEO, it's the assumption is this is what would happen to you in a disciplinary matter, because like the DC Bar's Legal Ethics Committee is not supposed to be issuing opinions on civil litigation. We've got no instances that we've been able to find of New York ever prosecuting anyone for a 5.6 violation. There's absolutely civil cases in New York where forfeiture for competition clauses have been voided on 5.6 grounds, but we don't see anybody being prosecuted. And indeed, the bar complaint that's being prosecuted here, the Montalvo bar complaint for 5.6 violations, was cross-filed in New York and didn't go anywhere in New York. New York didn't do anything with it. That's in the record. And I'm also informed that New York would allow, for example, a client to waive the right to file a bar complaint. So that's the 8.4D violation here. And that New York would allow a lawyer to agree not to file a bar complaint against an employer unless the complaint is one in which the lawyer would otherwise have a mandatory reporting duty. So that's also the 8.4D issue. And frankly, if Bar Council had charged New York violations, as we indicated in the brief, then the respondents would have put on a different case. They had retired judges who worked for them in the New York law firm offices, and they could have put those people on the stand to testify, hey, I'm a retired New York judge. I signed a similar template and didn't find anything wrong with it ethically.
And how far would that have gotten respondents in a hearing? That somebody else
it may mean that
they didn't think was a violation of anything.
It may mean that you would conclude that they hadn't violated New York law, but more importantly, we're not required to be proving prejudice in order to get the right rules applied. The rule matters because Bar Council is supposed to charge the right rule, and when they don't, they're not supposed to get the conviction. That's just the way it works.
Okay, thank you, Mr. I'm sorry. I'll let you wrap up, and then you have 5 minutes for rebuttal. Still.
Thank you. I know I'm way over, so I very much appreciate it. Let me spend a little bit of time, if I may, on the sanction side here.
2 minutes. 2 minutes on the sanctions.
Okay. So both sides went to trial here, believing that nobody had ever been publicly disciplined anywhere in the country for a 5.6 violation. Neither side was able to find a citation going into the trial. Neither side cited any 5.6 citation to the hearing committee. We as part of the briefing process here, we actually stumbled upon a couple of out-of-state cases that we cited in our briefs. And all of those cases signal that this, we've got a totally disproportionate response, both in the amount of time that's spent investigating, prosecuting, and on the sanction that the hearing committee has now recommended. We've got Maryland issuing an opinion that said, hey, look, the mere act that you've changed your fee agreement, or in that case, that you were willing to change your fee agreement, is enough to justify dismissing a 5.6 case. We provided you with a citation to a confidential, I believe it was Pennsylvania, private reprimand. And we had multiple reprimand cases from other jurisdictions. We have still found not a single case in which anyone has ever been suspended. And we would ask you to take that into consideration here.
right,
Thank you
thank
for
you.
letting me run over.
Sure, and thanks for keeping your sanctions argument pithy. We appreciate that. Mr. Fox.
Thank you, ladies and gentlemen of the board. Let me talk first about what information these lawyers had when they entered into these contracts. And I want to start with the Cohen v. Lord Day and Lord case, which is 35 years old, widely recognized as the seminal case in the area. And it happens to be a New York case. Now, I want to pause here for a moment on this concept of competition neutral, which is a completely made up concept. What Mr. Schumack is arguing is that if there is a restriction that applies to everybody who leaves, regardless of whether they go, as Ms. Cassidy suggested, to legal aid, into the Department of Justice, they join JAG. If it applies to everybody, then it's all right. There is nothing. There's no case that says that. There's no authority that says that. And the rule doesn't say that. The rule doesn't talk about competition. The rule talks about agreements that restrict the rights of a lawyer to practice after termination. And an agreement that restricts a lawyer to practice in the Department of Justice, in JAG, in the legal services is prohibited by this rule. And that's completely made up. And the citation to Ashcraft and Jarrell is, I don't know where to begin. The first thing is the lawyer in Ashcraft and Jarrell did not leave the employment of Ashcraft and Jarrell and receive a penalty, liquidated damages. He was fired. He was in charge of the Boston office, and the firm fired him and imposed a penalty on him. I'm sorry. So we're getting some. I guess there's some outside interference. I apologize. I'm trying not to talk.
I think does everybody except for Mr. Fox have their microphone on mute? Because sometimes there's feedback. I'm sorry, Mr. Fox. Go ahead.
That's okay. So the lawyer in Ashcraft and Jarrell did not leave the firm and incur liquidated damages because he left the firm. Mr. Schumack said that's false. It's not true. He was fired. And the contract said if he was fired, he had to pay liquidated damages. And then the U.S. Court of Appeals looked at it and said, well, it wasn't competitive. And somehow or other, Mr. Schumack has turned that around and said that if for some reason the liquidated damages are not competitive, whatever that means, are not imposed for a competitive purpose, they're fine. It doesn't say that. You can't impose a penalty on a lawyer for departing early, regardless of where they go or regardless of why they do it. And that's been the law for 35 years since Cohen.
But Mr. Fox, are you suggesting though, if a law firm pays a lawyer to take their bar, pays the lawyer for the bar prep class, and gives them a signing bonus of some dollar amount, and their agreement says that if you leave inside of 2 years, you've got to give a portion of that signing bonus back, are you saying that is prohibited by the rules?
I think it may be, but that's not liquidated damages. I suppose if you in my experience, most law firms don't have employment contracts, but I suppose that if a lawyer violated his employment contract and the firm could prove that they were damages, then they could sue and then, you would pay. But you can't have a penalty for doing so. I mean, if you could show damaged in that amount, yes.
So if a lawyer signs and their signing bonus is $100,000 and their employment agreement says if you've got to stay for at least 3 years, and if they leave after a year, you have to pay back a portion, 1/3 of the 100 or 2/3 of the $100,000 that we gave you when you signed, are you saying that violates 5.6?
I don't think it would, but that is very much not this case. This case, there were no bonuses anybody was paying back. They were having to pay a penalty if they left early. And as you yourself pointed out, if they had left to go to legal aid, they would have had to pay the same penalty. Now, the notion that this is new in the District of Columbia is just a canard. Let me go to the Newman v. Ackman case, which was 1998. We quoted this on page 34 of our brief. This is what the Court of Appeals said. We do note that courts have often invalidated various types of financial disincentives as indirect restraints on the practice of law, finding them sufficiently opprobrious to be barred by the ethical rules. That was what our court said in 1998. Now, there have been multiple legal ethics opinions starting in 1987 that condemned liquidated damages except in an extremely narrow circumstance where it was imposed because a lawyer had made a direct solicitation of a client and taken the client with him. And even then, the ethics opinions emphasize that the lawyers have the right to generally solicit those clients by at least sending announcements. Then in 2007, 3 years before any of these contractual provisions were written, the court amended the Rule 5.6 to add comment number 2. And comment number 2 says that the restrictions that are prohibited can include substantial financial penalties. That was done in 2007. So all of this was available. All of this should have been known to them before they entered into business in the District of Columbia. And you would think that a law firm, like any other business that's going to open up shop in the District of Columbia, ought to find out what the rules are in the District of Columbia. Passing that, in 2015, 3 years before they ended the practice of seeking of liquidated damages for early departure, Legal Opinion 368 comes out, specifically addressed to this law firm. It doesn't, and they still continue to do it.
Mr. Fox, when you say still continue to do it, what exactly, because there was a change in their templates, right? From before 2015 to after 2015. What, in your position or your argument, what is that they still continue to do with specificity?
They still included in their contracts liquidated damages clauses for early departure, and they attempted to enforce them after Opinion 368 came out. And I think that shows you the lack of good faith in which they were engaging. All right.
Mr. Fox, pivoting a little bit from using your comment, lack of good faith, your office starts its brief calling the firm an oppressive sweatshop. That, even assuming arguendo that was true, does that have anything to do with the rule violations we're facing today?
Yes, it does. Because the reason that you have autonomy for lawyers is so that if they have to work in a shop like Tully and Rinke, and they have to be subjected to the conditions that they were subjected to at Tully and Rinke, they're free to move on. And they're free.
Mr. Fox, wouldn't that be the case then? Wouldn't that be the case then that our court system in no instance would allow for a non-competition of former employees, so that if non-competition is out there to avoid or help someone not have to work in an oppressive sweatshop, would not the courts have taken up this mantle and prohibit non-competes for any employee leaving anywhere?
Well, I think they're actually doing that. But there is a special rule for lawyers. I mean, the future of non-competes, I would suggest, is probably not bright for all across the professions, but there's always been the case that you can't have a non-compete for lawyers.
But Mr. Fox, help me understand how that comment supports whether or not the respondents violated Rule 5.6 or any of the other rules you've charged them with.
I'm sorry, the comment.
your comment that it's an oppressive sweatshop. How does that that assuming arguendo that fact is accurate, how does that fact go to whether or not the respondents violated the rules that you have charged them with?
Yeah, well, the fact, and it's a metaphor, but the metaphor is accurate, and the findings of the hearing committee, I think, demonstrate that. And the reason is the purpose. It shows the evil of imposing these sorts of restrictions, because they have an interim effect on lawyers to stay in a situation where they don't want to stay. Because if they don't, they'll incur a substantial financial penalty. Let's take Ms. Gregerson. Ms. Gregerson had a medical condition. She wanted to leave. Her doctors were telling her to leave. She was scared to leave because of these financial penalties. And so interfering with her autonomy, interfering with any lawyer's autonomy, is the evil that Rule 5.6 is designed to prevent from occurring. And so that's why it's relevant.
Mr. Fox, can you address Mr. Schumach's assertion that the predominant effect of the conduct at issue here was in New York and not in DC?
I don't even think Mr. Schumach goes, well, maybe he does go that far. I think what he says is that you shouldn't get to the predominant effect thing because you could.
Well, I think he was indicating if we do,
right,
the effect was in New York. Can you address that succinctly, please?
Well, I think the succinct response to that is that these were lawyers, every single one of them, the hearing committee found 12 of them worked in the Washington office. None of them worked in the New York office. They worked in the Washington office. A couple of them spent some time in the Virginia office, but the predominant time that they spent was in the Washington office. And the clients were clients of the lawyers in the Washington office. So the predominant effect of the restriction on lawyers' ability to leave the practice, the Tully and Rinke, and go practice in another law firm was in the District of Columbia. And I don't think I can be any more succinct than that. Let me turn, if I may, to the question of sanction here, because I really think that that's what we're talking about. The respondent's brief is a little schizophrenic on that, because on the one hand, they seem to suggest that everybody does this or has been doing this for 50 plus years, and disciplinary counsel hasn't been doing anything about it. And then they said, but there's no need for deterrence. Now, to me, those are divergent arguments. We have a complaint-driven system here. And so our ability to go after these sorts of situations depends on the kinds of complaints that we get. And the second thing to remember is that we don't have jurisdiction over law firms. We have jurisdiction over lawyers. So you take the Gentner case, which somebody said Mr. Schumach had cited 48 times, I think. I don't know. I didn't quite get the count. The Gentner case, he points out in his brief, the prohibitions that were in effect had been enacted before 1990, or at least as of 1997. And this was the case that was decided, 2018 or something like that. What lawyers entered into what agreements when, I don't know. But nobody you can assume that nobody's complained about the Gentner case. It's a complaint-driven system. We have a unique situation here where, in effect, the two people who managed the firm were the only equity partners in the firm, and they were the people that imposed these restrictions. And I don't think there's any factual dispute about that. So that's why we have this is so it's in some ways it's not comparable to any other situations.
Excuse me, Mr. Fox. With respect to the agreements, respondents point to 5 cases in other jurisdictions where the respondents were publicly admonished for violations of Rule 5.6a. One reason that you say these cases are not analogous is that there were simply more agreements at issue here. How do we consider that?
I'm sorry, I didn't mean to interrupt you.
That's okay. Isn't the issue that because these were template agreements, respondents simply repeated the misconduct as a consequence? So why should we consider each agreement individually as a discrete rule violation?
let me give you, I'm not sure. I don't know that I would say you should consider each one as a discrete rule violation as much as you consider the cumulative effect. Let me give you 7 reasons why I think a suspensory sanction should be imposed in this case. First, this conduct was deliberately intended to prevent lawyers from leaving the firm. That was a finding of fact by the hearing committee. It's in finding number 22. So the thing that it explicitly is prohibited by Rule 5.6, they intended to do. That's the first thing. Second, and this goes back to the point I think I was making with Ms. Cassidy, it was done in order that people could not escape these oppressive working conditions that the firm imposed on. Those are things that are different than all the other cases. Third, they had plenty of warning in advance that this was impermissible contact. The statement I read from, in the Newman case, and I forgot to mention this earlier when I was going through the information they had. In 2007, I did mention it. Comment 2 was added to the to the rules. So that was all done before. The multiple legal ethics opinions, the objections of some of the Tully-Rinke lawyers to some of these provisions, LEO 368 specifically written for them, and their failures in their various arbitration and litigation to be able to enforce these kinds of provisions. They had plenty of warning that this was illegal conduct. Fourth, and this may go more to your actual specific question, there were multiple kinds of restrictions, not just that they were on multiple people, but there were multiple kinds of restrictions. You had the liquidated damages for early departure. You had the prohibition on practicing with firm alumni enforced by another liquidated damages clause. You had the prohibition on recruiting Tully-Rinke lawyers enforced by another liquidated damages clause. You had a prohibition on taking contact information of your own clients enforced by a liquidated damage clause. They had this practice of before a lawyer left, they would transfer all of her clients to someone else, say, okay, you don't have any clients, so you don't have to notify, you have no obligation, and you're prohibited from notifying any of your clients. Another way of restricting her ability to move, at least for her clients to go with her. You had this kickback of legal fees. They call it fee sharing, fee splitting. It's a kickback. They had a requirement in there in perpetuity that if you left and took a client with you, some percentage, in some cases as high as 50% of all the fees had to be paid back to Tully-Rinke. And then, of course, you had all these oppressive provisions about what would happen if you actually litigated. You had to do it in Albany, New York. You had to pay your expenses. You probably had to pay their expenses even if you lost. All of these multiple provisions, nothing like that in any of the other cases that Mr. Schumacher has cited. The fifth reason, this lasted for 7 or 8 years. We don't have a situation like the case in Maryland that he just talked about, where somebody pointed it out to them and they took it out of their agreement. These were provisions that lasted for 7 or 8 years, including past the time when LEO 368 came out. The sixth reason, it was applied to at least 12 lawyers. We offered testimony about 12 different lawyers, put in contracts from 12 different lawyers. None of these other cases have anything like that scope either. And finally, a factor that seems to get lost in a lot of this discussion, indeed, I don't think it's even been mentioned today, that in addition to these restrictions on practice, they had this prohibition on voluntary cooperation in any investigation. And, that seems to have dropped almost through the slats here, but that nobody else had anything like that. And so that is the reason that I said, those are the reasons that I suggest to you, the 7 reasons why a suspensory suspension is necessary here. Now, we said 6 months. The hearing committee said 90 days. I don't know what the right number is. I think if you got much lower than 90 days, it might not have much deterrent effect. But it needs to have a deterrent effect, and it also needs to be a statement by the profession and by the court that this kind of conduct by a law firm cannot be tolerated. Law firms are businesses. We all understand that. But we are a profession. And
Mr. Fox, there are some findings by the hearing committee related to the respondent's credibility. How are we, it's going to be a two-part question for you. How are we supposed to take those findings when it comes to sanctions? Like at one point, the hearing committee says the respondents were largely credible. They find that they give contradictory testimony or make post hoc rationalizations. How do we consider that for sanctions, but also for, since that's sort of a mens rea type of question, how do we consider what they were, what they were supposed to know or what they were supposed to understand when they were drafting these provisions? And are they not allowed some leeway in interpreting how 368 gets applied to their templates? And could they not have just made arguably a misinformed decision on revamping their templates?
For the life of me, I don't see how anybody could read Opinion 368 and say that it's still okay to have these liquidated damages clauses for early departure. And particularly when this competition neutral thing is a completely invented rationale that has no basis in any case law whatsoever. So I don't see that. To come back to your first part of your question with respect to credibility, we argued, as you know, in front of the hearing committee that there were at least 3 instances in which these respondents gave false testimony. The hearing committee, in what I think was an exceedingly generous 3 sets of findings of fact, and I forgot the numbers, but they're all grouped together in the report, said, well, we don't find that they actually gave false testimony, but they don't find the testimony to be credible. And the one that struck me the most was Mr. Tully gave one explanation for why they still kept the liquidated damages for early departure clauses after 368. Mr. Rinke gave another. The hearing committee said, well, neither of these are plausible. And because they're so implausible, and I'm paraphrasing here, but I really think it's a fair paraphrase, because they're so implausible, we don't find that they deliberately intended to mislead the hearing committee. Now, that to me is an exceedingly generous finding on the fact of the hearing committee as far as these respondents are concerned. But I do think you ought to consider that they did give testimony that was rejected and was found in part not to be credible. I don't know that it's enough to ratchet up the sanction, but I do think that the sanction, even without that, has got to be a suspension of some length. If there are no other questions, I'll.
No. If there's no other questions from any board member, thank you, Mr. Fox. Mr. Schumack, you have 5 minutes rebuttal.
Mr. Schumack, you're on mute.
Can you hear me now?
Yes, yeah. Don't mute yourself again.
If I could get an extra 15 seconds, that would be great. So, I'm mindful of the questions that Ms. Cassidy asked and the responses that Mr. Fox gave, right? So, workplace environment has absolutely nothing to do with any of the charged offenses. We've got security cameras in the workplace, like many other law firms. They had high billable requirements, like many other law firms. And, frankly, the feelings of disgruntled employees are not a disciplinary offense. They had 6 years to investigate this case. There is nothing in the record to indicate that anybody had ever made any kind of claim about a workplace violation. The word sweatshop did not come out of the mouth of a single witness for disciplinary counsel. And I would suggest to you that, yeah.
Mr. Schumacher, thank you for that, but I do want to follow up on something with sanctions. How do we address issues of credibility when it comes to thinking about sanctions? And I'm referring you to a hearing committee report finding at 53, where Mr. Tully testified that they had not collected damages, but yet both Ellis and McCullough had made payments to the firm that Mr. Rinke conceded were in fact liquidated damages. And there's a couple other points where the hearing committee says your respondents were largely, but not always credible. How do we square that as we analyze sanctions?
Sure. So on the liquidated damages discrepancy, I believe Mr. Rinke's testimony was that the documents that those two lawyers signed wrote it up as liquidated damages. Mr. Tully offered an explanation that the hearing committee referenced in a subsequent finding, indicating that there was a plausible basis for Mr. Tully's testimony that the two subject employees who had these write-ups for liquidated damages were actually reimbursing the firm for something else. So there's no meaningful discrepancy there. We responded on the briefs to the hearing committee to this, allegation in Mr. Fox's closing argument to the hearing committee that, gee, you need to give them at least 6 months because they lied to the committee. We responded to that. If that's an issue for you all, I would implore you to go look at how we challenged that allegation in our post-closing brief to the hearing committee. Credibility means a lot of things, right? You've got a 6-year investigation here that starts on a different case in 2016, and then with the Montalvo complaint in 17. You've got questions that are being asked of these two respondents over a series of non-consecutive days of testimony. They got put on the first day by Mr. Fox. They were the last witnesses in their own case in defense. And they're testifying to things that happened in 2009, 2010, 2011, 12, 13, 14. So it shouldn't come as a surprise that they're not going to remember everything that happened in all of those years, and that they might have disparate recollections. I mean, what are we talking about here? If they'd shown up with exact lockstep testimony, were we then going to hear that, well, they were obviously comparing notes on their testimony? So, credibility encompasses somebody who is mistaken. Credibility encompasses somebody who lies. There's an explicit finding that they did not lie, that they were not intentionally deceptive to the committee. Mr. Fox has said, he said, finding 22 explicitly says they deliberately wrote these documents to violate the rule. I don't know what he's looking at. I don't see anything to indicate a deliberate or intentional rule violation here. In fact, the hearing committee seems to have gone very far out of its way to suggest that none of these rules, including the 8.1 things, actually require intent. So that's very confusing stuff. This case should have been about the templates. We got a 6-year investigation that didn't result in any new evidence besides the disgruntled employees that Mr. Montalvo identified in his bar complaint. The trial on this matter, again, it expected the respondents to remember stuff that happened 10 years prior to when they sat on the stand. We've got bar counsel's own witnesses, some of them acknowledging that, I stole stuff from the firm. We've got, firm's advertising records walked out the door. We've got client lists that walked out the door for clients that nobody had ever worked for. So, we shouldn't be talking here about the workplace environment. It's not germane to the ethics issues. Look at the contracts. They're not perfect. Obviously, we have conceded over and over again in writing to the hearing committee, in writing to you. We had testimony. If we were looking at these documents and they were being imposed in 2024, they're not going to pass muster under Gentner. No doubt about that. But Gentner didn't do anything to disturb Ashcraft and Jarrell's allowance for what we call competition neutral penalties. Gentner itself is limited to penalties for competition.
Thank you, Mr.
So-
Schumacher. Thank you. Did you have a statement to wrap up or?
I do, if I may.
Yes.
Thank you. You're so kind. All right. So, this isn't a misappropriation case. Maybe Bar Council could justify the Spanish Inquisition in a misappropriation case, but that's not what we're dealing with here. Even on the 8.4D charge, nobody's ever been suspended in DC for contracting to preclude or contracting to withdraw a bar complaint. The hearing committee cited a case in which Bar Council gave somebody an informal admonition. I've given you a case, the Priest case, where there was no violation for a request to withdraw a bar complaint. And the Martin case, which is truly the most offensive conduct on the planet, it's got an 8.4D violation for an obligation in a civil settlement to withdraw a bar complaint, but that's not the core of the sanction. The Martin case was about dishonesty. Bar Council actually asked the Court of Appeals in its briefs in the Martin case to disbar Martin for flagrant dishonesty. The 8.4D piece about the settlement agreement looks like nothing in Martin. It's all about the other misconduct. There was a whole separate 8.4D problem in Martin based on his frivolous litigation tactics trying to get out of a refund that he owed his client.
Okay,
But
thank
for
you,
the-
thank
the-
you,
the-
thank you, Mr. Schumacher.
I appreciate the allowing me to go over on both ends. And I thank the panel for its consideration of this matter.
Okay, thank you very much for your arguments. Very helpful, both counsel. And we will